Good morning, everyone, and welcome to our discussion on how the 2025 SBA rule will impact your GovCon small business value. I know we have a lot to get through today, so let's just get quickly and jump to introducing you to our distinguished panel. Our first speaker, Sharon Heaton, is the founder of sbLiftOff, a national M&A firm, which serves owners in the government contracting space. Sharon has advised on transactions totaling more than $12 billion in deal value, and focuses on bringing high-quality M&A advisory to the mid-market GovCon space. Sharon just released the second edition of her book, Liftoff, 12 Things to Know Before You Sell Your Company, published by Forbes and available on Amazon. Appointed to the Small Business Administration's Investment Capital Advisory Committee, she works nationally to increase small business access to investment capital. Next, we have Sai Alba. Sai is a partner at Polera Mazza and counsels clients on a broad range of government contracting matters before government agencies and federal courts, which includes overall regulatory compliance with the SBA small business programs. He represents small and mid-sized government contractors looking to structure compliant teaming, joint venture, and mentor-protege agreements. Sai also handles the prosecution and defense of small business size and status protests, appeals before the SBA and the Office of Hearings and Appeals, as well as bid protests before the Government and Accountability Office, the Court of Federal Claims, and the U.S. Court of Appeals for the Federal Circuit. That's a mouthful, Sai. Next, we have Todd Overman. Todd has established himself as a leading government contracts practitioner at Bass, Berry & Sims. He is a managing partner of the firm's Washington, D.C. office and the chair of the Government Contracts Practice Group. Todd has nearly 2 decades of experience advising companies in meeting the demanding and ever-changing regulatory environment of contracting with the federal government. Over the last decade, he has advised on more than 50 transactions involving the purchase or sale of a government contractor. Next, we have Marlena Ewald. Marlena is a partner and serves as vice chair of Fluet's government contracts practice, as well as head of the firm's government contracts regulatory compliance section, where she specializes in corporate and government transactional matters. With a focus on government contracting, commercial contracting, and sensitive government inquiries, Marlena provides expert advice and counsels to companies and individuals. Over the next hour, we encourage you to submit your questions through the Q&A option at the bottom of your screen. You can submit questions throughout the presentation, and the panel will make every effort to answer your questions. I know we have a lot to get to, so let's get started. Sharon, I'll turn it over to you.
Fantastic. This is one of the more important rules that the SBA has released as it relates to federal government contractors. We have some slides that we'd like to walk through. Kyle, if you could put those up, please, so that we can kind of lay out the overview of what's happening here. This might be some of the more important rules since, let's say, the mentor-protege rules of over 10 years ago. The SBA released a final rule that was issued in December and became effective January 16th or 17th of this year. The rule is quite lengthy. There's lots of things in this rule. We're only going to be talking about one element of it, which is the size recertification changes. I'd like to throw this over to one of the lawyers to start this discussion to make sure that we can lay out the groundwork of what it is we're talking about. Sai, would you mind taking the first shot at this?
Sure. Yeah. So, SBA loves to change their rules. They love to update them on a fairly regular basis. But as Sharon noted, this one is a little bit more extensive. And the main changes here, sort of moving away from a one-size-fits-all recertification to having different types of recertifications, specifically of qualifying and disqualifying, right? And what they did is they created a situation where if you recertify as small, so after a merger, after an acquisition, there's a 5-year recertification rule in long-term contracts, any of those. If you recertify as small or as eligible as whatever the set-aside status is. So if it's an 8A contract, you recertify as small and 8A, for instance. If you do that, it's a qualifying recertification. And in those cases, there are certain implications to a qualifying recertification that are positive, like keeping work. And this is things we'll go over a little bit later. But you get to keep your work. You don't have to worry about losing anything on single award contracts, on multiple award contracts, on any of that. If you recertify, you're good to go until some future recertification event that is triggered by a separate event. If you have a disqualifying recertification, though, that is a new concept that was created in this rule, and kind of the main concept that we're going to be walking through and the implications of that kind of disqualifying recertification. Essentially, that means you go through a merger, you go through an acquisition, or the 5-year recertification, or the 180-day rule, which we'll get into that too. Any of those sort of recertification scenarios, or frankly, if a contracting officer requests that you recertify as part of a task order bid or something to that effect. Any of those scenarios, if you have a disqualifying recertification, that's when there are much stronger negative implications, pretty draconian implications that are under this new rule that did not exist under the prior regime. Because under the prior rule, even if you weren't eligible, like you were a large business or you were no longer 8A or woman-owned, et cetera, you could continue to keep contracts, even multiple award contracts. You could bid task orders. You could do all kinds of things. And that is changing. So what we're going to be
Sai,
going
I'm
through
going to
here is
cut you
more of
off
that.
there because we're going to talk first about the recertification, then we're going to talk about what are the implications of this. Marlena,
Right.
can I ask you, am I correct in thinking that they have not changed the recertification rules per se? What they've really changed is the effect of the recertification or disqualifying recertification. Is that a fair assessment?
Yeah, I think that's generally true. You're still gonna have to recertify within 30 days of a merger or sale acquisition, within 30 days of innovation. It's just the implication, as Sai was kind of, I think, starting to cover of that recertification that has changed for contractors moving forward after the state, which we'll get into the 1-year delay as well. I don't want to jump too much ahead, but yeah,
I
so
was
essentially, I
literally,
think.
that's fantastic. I love, Todd, I was about to ask you, this rule is in effect, but this disqualifying recertification has a delayed impact. When does it take effect, and what do you think is the significance of that 1-year delay?
Well, the 1-year delay is a bit more narrow than I think most people probably recognize. It only really applies, the 1-year delay on a disqualifying recertification only really applies to multiple award set-aside contracts or set-aside max. It doesn't apply for the pending proposal portion. It doesn't apply for GSA schedules. So it's a fairly limited, but potentially important delay effect. And what it basically says is that you could have a disqualifying recertification over the course of the next year or before January 17th, 2026, 17th or 16th, one of the two. That won't impact the negative consequences of a disqualifying recertification for a multiple award contract, set aside multiple award contract.
Okay, so let me do a fast summary, and please correct me if I get any of this wrong. Basically, there's a rule that went into effect in January of this year, this month, and it basically deals with recertification. When do you need to recertify, and what is the effect of a disqualifying recertification? A disqualifying recertification, in the case of an M&A, a buyer is not able to meet the set-aside standards of the seller. So let's say it's an SDVOSB seller, and the owner, the buyer is a other than small company. That is a disqualifying recertification. What I heard you just say, Todd, is that the 1-year delay is kind of limited because this rule already exists for some vehicles, like a GSA schedule. If you have a disqualifying recertification today, the rule that the SBA has adopted is kind of already in effect. That's also true for certain fairly large vehicles. I think that there's it's T4NG or others that already have this kind of rule in. So what the SBA seems to be doing here is saying, we've been doing this a little bit on an ad hoc basis for the GSA, for specific BIC contracts, specific MAC contracts, but now we're making this a universal across the board consequence for a disqualifying recertification. Todd, did I get that right?
Yeah, I think I guess the distinction I make, I would agree with you that there have been and are currently in place, on-ramp and off-ramp provisions in certain MAC contracts, right? So you've had situations in the past where you've done a deal and based upon your recertification, you're off-ramped because you can no longer compete for a set-aside order under that vehicle. So those have existed in certain multiple award contracts. I mean, the GSA Schedule 1 has been around, is now around for 13 days. So for GSA schedule purposes, there is no delay. So there is no 1 year. So as of today, if you have a disqualifying recertification, you are no longer eligible for set-aside orders or set-aside BPAs under your GSA schedule.
Understand. So this rule actually has already taken effect as it relates to GSA contracts under GSA. Let's go to the next slide. Marlena, could I ask you to take a shot at this? Because again, this goes to the recertification that's required. And while there's a lot of words on the page, I think that it is actually saying that, hey, recertification can occur at many times, not simply an M&A, but the rules on recertification aren't dramatically different. The consequences are. Tell me, give that to me in your words or correct me if I'm got that wrong.
Yeah, sure. So I think you're right. I agree. Generally, like we've said, I think before, just so we're on the same page, right? It's 30 days. You have to recertify within 30 days after an acquisition or sale or merger of a company, including affiliates. If you're a member of a joint venture and you've gone through that process, you also have to recertify. If you are the acquirer, so not just the target company, not just the acquired company has to recertify, but if you're the acquirer and you have a set aside contract, you also need to recertify. And then there's the 5-year rule, which is remain the same within no more than 120 days prior to the 5th year, you have to recertify. So those are essentially the same. The qualifying, once you make that recertification, so if you're still able to recertify as small, right, that should continue to qualify you for that contract for the next 5 years, unless there's another disqualifying event. If you are not able to recertify as small, that is what we've been talking about, the disqualifying recertification. Then the rules have now changed. Well, as Todd was saying, there's a 2-year delay for a portion of them. But moving forward, if you make that disqualifying recertification on set aside multiple award contracts, starting January 17th, 2026, you'll no longer be able to bid on task orders or exercise options for those set aside multiple award contracts.
So let me ask you a question on that, because many people have said to me that one of the things that seems like a big change is that the acquirer needs to recertify themselves. And my understanding, in fact, is that under the current rules, when there is a recertification after an acquisition, both the combined entity, the buyer and the seller, are recertifying, so that a buyer who might have sized out now is recertifying and is acknowledging that they are other than small, even before the acquisition, not simply as a result of the acquisition. Marlena, is that correct?
So just to clarify, now it is correct that the buyer and seller must recertify. The buyer, right, it's really only going to matter if the buyer has certified as small, right, because it's recertifying, presumably, if now combined with the small business, right, they're now other than small. The buyer and the seller are recertifying as other than small. I know we have this on a later slide, so I won't go too much into detail. There is an exemption for 2 small businesses and what implications are there. But yes, generally now the buyer and seller must recertify their status.
Excellent. Let's go to the next slide. Guy, I'm going to throw this back to you. I stopped you before, but this is the heart of the matter. So what is the impact of a disqualifying recertification? If you could discuss a little bit about what the current law is, and then how this changes as a result of this new SBA rule.
Sure, yeah, and this is where I think the fundamental difference, like you said, the main issue is that currently, if you have a recertification that is disqualifying, although it wasn't defined like that, or I shouldn't say currently, under the old rule, even if it was a multiple award contract, you were able to get option years under that multiple award contract. Again, the caveat is if there's specific contracts that have an off ramp, that might be an exception. But generally speaking, you could keep getting option years and you could keep bidding on set aside task orders that you technically didn't qualify for under those multiple award contracts. But the agency could no longer take small business or whatever designation credit for the dollars they spend on you. That was the old rule. And so a lot of times, if a contracting officer was happy with you, they would let you continue performing and they wouldn't terminate, they wouldn't off ramp, again, unless the contract said otherwise, and they would let you continue performing and potentially bidding and winning more work. Under the new rule, however, if you have this kind of disqualifying recertification where you recertify as no longer being eligible for multiple award contracts after this delay period, you will no longer be eligible for option years under those multiple award contracts under the umbrella IDIQ level. And you will also no longer be eligible to bid new task orders that are set aside that you are no longer eligible for based on your recertification. So that is the really major change here, is those two distinctions.
As somebody who focuses on the M&A side of government contracting, we've been telling people for years, if you were a set-aside company and you want to sell, build up your management team, work on your margins, and get as much backlog as you possibly can. Under the current law, if they had a lot of backlog and they were acquired by somebody who was other than small, that acquirer could exercise that backlog, but might not be able to recompete it. And the government wouldn't be able to take credit. Under the new rule, that acquirer would not be able to exercise the new option years in that backlog. You would not be able to bid on new task orders, and you can't be awarded task orders that you don't have until we get to the 180-day rule. Sai, is that a fair summary of it?
Yeah, I think generally that's what it would mean. Anything you haven't already won, you're essentially, as a general rule, anything you haven't already won, task orders, you wouldn't be able to get new ones, is what would occur under the new rule, right?
We looked at one company that had a lot of backlog, great margins, great management, all that kind of, and just looking at it a very mechanical point of view, they had something like $70 million of backlog that could be transferred under current law. And under the new rule, depending upon who the acquirer was, they had less than 10. So it can have a very significant impact on how buyers look at selling companies and how they're going about valuing those companies and what they're looking for. Todd, do you have any thoughts about this slide?
Yeah, I think the thing to to keep in mind, and you're talking about kind of buyer's assessment of a small business. I mean, as you mentioned, we've always been doing diligence, thinking about what works, what's going to stay, what can be recompeted. And I think, you have to keep in mind that they've made this distinction between, the single award set aside contract is effectively fine. Okay. It's the multiple award set aside contracts that have really proliferated in the last 5 to 10 years, and small businesses have gone out and got all these different vehicles to have that. Those are the ones that are really impacted. So when obviously when a buyer is doing diligence, they're going to assess different value based upon whether you are holding single award set aside contracts. Those will continue to have, I think, the same sort of value versus those multiple award set aside contracts where I think, Sharon, you are correct. They're significantly decreasing in value.
Okay. Marlena, is there anything that you want to say about this slide before we move on?
No, I think we pretty much covered it. The only thing I know that was on the first slide that I want to make sure that we touch on is, this doesn't necessarily have a retroactive effect. So any deals that have closed, right, before this went into effect are not, their contracts will not be affected by this.
So one of the factors is if you want to do a deal, 2025 might be the year to do it. Because you're not going to be under these new rules. You will not lose your backlog. But if you did exactly that same deal in February of 2026, and this rule is in effect, there could be some significant consequences. Is that a fair assessment?
Yeah, so for multiple award contracts, I think like Todd mentioned, right, for the options and for task orders, as long as the deal closes before January 17th, 2026, those rules, the ineligibility rules will not apply until after that date.
Sharon, there was a question that an audience member had on terms of,
Please.
how do you make this certification? Where does it go? That sort of thing. So I wanted to make sure we are connecting the dots for folks a little bit. We're talking about the SBA rule, and it's a new section. Keep me honest here. I think it's 13 CFR 125.12, which sets forth the recertification requirements. All right. The FAR takes that and puts that into the clause that we've always makes it a contractual requirement in 52.219-28. And that's the post-award small business program representation requirement. That has effectively been the place that you look in your contract to see, well, do I have a requirement to provide a post-award small business re-representation? And when you know it, I mean, that clause has already been updated to around January 17th to reflect some of this. So those are kind of, you connect the dots there between the FAR and the 13 CFR. And then, just as a matter of practice, what you tend to do in a deal is you provide a written notice, usually an email or a letter to the contracting officer, and you let them know that you've had this event and whether or not it's qualifying or disqualifying, and that you therefore have updated your status or reconfirmed your status as small or other than small in SAM. So you're providing a notification per the clause, but the clause talks about the vast majority you're able to do in SAM. Sometimes you're not able to, but the vast majority of them, you just make your update in SAM. And that is what then, at least you've satisfied your requirement to provide the re-representation that due to the triggering event.
Excellent. Let's go to the next slide just for a moment. We're not going to walk through this in great detail, but this basically shows an example of a company that would be purchased and there'd be a disqualifying event and the significance of the difference between under the current law versus under this new rule. These slides will be available to people, so I'm not going to go through this in great detail, but it will indicate the significance of how the valuation could really change. Let's go to the next slide. And Sai, I'm going to ask you a question that came in from the audience. If you have a set-aside company and you turn it into an ESOP, does an ESOP count as a disqualifying recertification?
Yeah, I think that kind of nuance I've gotten into a number of times with deal structuring. So the recertification rule itself, and you kind of got to look at the 13 CFR 125.12 that Todd mentioned more so than the FAR for some of the nuance, which is another thing people should remember, that the SBA rules apply to every set aside. So technically, even I think if the FAR is not in your contract, those rules still apply to you. So pay attention to that, because there was a question about a contractor or an agency not requiring it. That's not really relevant. So be careful. But if you have scenarios where you're not doing a merger or acquisition, which isn't, by the way, clearly defined, or a novation, which is obviously defined in FAR 42.12, if you are hitting one of those squarely on the head, you have this recertification event. Now, I think in the case of an ESOP, I'm not sure it's that square on the head. There might be arguments to be made there. Like if you did contribution agreements, if you had ownership of multiple companies and you were contributing ownership interest from one to the other, is that a merger? Is that an acquisition? Or is it just a contribution? In most ESOP cases, I would assume that the owner is selling to the ESOP. But there could be some nuance there. So I don't know if there's a very direct 100% answer, in my opinion.
This is a new rule. It's less than a month old, so there's definitely going to be ambiguities. From a 100,000-foot level, in an ESOP transaction, the owner is basically, who might be an SDVOSB, woman-owned, whatever it might be, is now selling to a new entity. That new entity is the ESOP trust itself, and that ESOP trust does not have the certification of SDVOSB, woman-owned, etc. So it certainly would raise eyebrows. Maybe there is some way of getting through that morass, but it does not seem to be an easy answer. Is that a fair answer, Sai?
Yeah, I think the easy answer would be yes, it is an acquisition you have to recertify. If you wanted to avoid that, that's where I think we'd have to dig deeper and see if there's an argument.
Okay. Now, Marlena, one question came in. I'd like to ask you this one directly. And this came in and said, so if I want to sell my firm as a woman-owned small business, and most of my contracts are under the GSA schedule, would the buyer need to be a woman-owned small business, or somebody who could qualify as a woman-owned small business, in order to purchase from the seller? I want to be clear on this.
Sure. So just because you're a woman-owned small business, you do not have to sell to another woman-owned small business, to be clear. However, right, if you have contracts that are set as that the company has been awarded as a set aside for woman-owned small business, and then you do not sell to a woman, with 51% or more ownership and control and all of those fun rules, then you no longer qualify. If it's a single award, and I'll get to the GSA, I think specific question. If it's a single award, you can continue under the new rule. You can continue to perform that contract. If there's BPAs under that single award, you can continue with those. But if it is a set aside multiple award contract, you are not going to be able to continue if you cannot recertify as a woman-owned small business and it's been set aside for women-owned small business. You will not be able to continue to exercise options or get task orders, assuming that this has occurred, on January 17th, 2026 post, right? Obviously, if you do it this year, we're talking a little bit differently because the ineligibility rules don't apply. Now for GSA federal supply schedules, I think Sai or Todd mentioned this before, we don't have that delay. And so now the schedule itself is generally unrestricted, but if a task order, right, is set aside for a woman-owned small business, and you do not sell to a woman-owned small business, they will no longer be eligible for that award. I know we have a slide on the 180-day rule, so we can talk about what that looks like and the implications there, but that's kind of the high level, clear answer distinction.
Great, thank you. Todd, I'd like to ask this question of you that came in from the audience. The new rule doesn't seem to apply to MACs before 2016. That is, you're not under the GSA schedule. It's not a single award contract, it's a MAC. And you do the transaction before the new date in January of 2026. The question is, are the option years and bidding on new task orders, say in 2028, are you allowed to bid under the current rules, even though it's after 2026?
Well, I think what's important is when did your triggering event occur?
Let's
Right?
assume that the acquisition was done in 2025.
Yep.
So you're beating the rule. It happened before it becomes effective. You're not dealing with the GSA schedule. You're dealing with a MAC that already doesn't have an off-ramp in it. So you're right within the scope of this rule. You are beating the triggering date, but it's now 2028. are you still able to bid on task orders
Yeah,
under those max?
Yeah, you've not had a disqualifying recertification. So unless there has been a specific request for a recertification from a contracting officer, but you've not had a disqualifying recertification.
Absolutely. Before we do more questions, let's kind of talk a little bit about what's on the screen right now, because this is also a significant change. Sai, would you mind talking about the protests possibility for qualifying recertifications? This is also something that's new.
Sure, yeah, like, and under the old rule, generally speaking, you couldn't protest someone's size as it relates to their bid on a task order under a multiple award contract, because unless there was a recertification expressly requested by the contracting officer for that specific task order bid. That was the old rule. And the idea there was, if they didn't expressly request recertification in connection with the order, your size goes back to when you certified under the original IDIQ. So in a situation like something like COSP4 or something where it takes years, you might have recertified way back in 2023, and it doesn't get awarded till 2026. You bid on orders. Nobody was supposed to be able to protest you because they're late. Your size was determined years ago, and they're supposed to have 10 days from the date that you did that way back when. The new rule, though, says that if someone bids on a task order, and they're not eligible, you don't think they're eligible, then you are allowed to protest. So that's the major change. They're allowing size protests to occur to challenge people's size on a task order basis, as opposed to under the original IDIQ. And that's true even if you have a situation where a government official, the contracting officer, hasn't expressly requested recertification, because this is how they're going to enforce the new disqualification that we've been talking.
Absolutely. There is now another means by which competitors can challenge the size of awardees under these contracts. Is that a fair assessment?
Correct. And SBA could have done it before. The contracting officer arguably could have done it, but not competitors. Now they can.
Great. So we can expect there to be more protests of qualifying recertifications.
Most likely. Yep.
Okay, let's go to the next slide. Todd, I'd like to ask you to take the lead on this one. This is incredibly important for people to understand, because while the rule is both broad and has some significant impact, it doesn't apply across the board. So we want to talk a little bit about the areas where the rule doesn't apply. Todd, would you take the lead, please?
Yeah. So in terms of things that don't apply, I think we've mentioned these already, but just to reemphasize. So a single award set aside contract is not impacted. So you can continue to perform, you can have options exercised, and you can receive orders. Similarly, an IDIQ or BPA that has a single awardee is not impacted.
And let me ask you a
However,
question on that one, Todd. What if it's a single awardee, but it's under a GSA schedule?
a single awardee.
Well, you get a contract under a GSA schedule, but you're the only awardee. But the GSA basically doesn't have the 1-year delay. Is in fact that contract able to be transferred to somebody who doesn't have that same set aside designation?
Well, you're able to, I mean, if you have a GSA, if you want a GSA set aside task order, right? You are able to finish the task order, just no options exercised or no new bids that are set aside under the GSA.
Got it.
And so, like, again, like we were talking about, it's these multiple award set aside contracts, or MACs, so multiple award set aside MACs, where you're not eligible to bid on future orders and you can't have your options exercised. So we've got this. I think Marlena mentioned this before. There is this kind of small to small exception that's been created. That is, if the acquirer is also a small business under the NAICS code assigned to the contract. And though even though together they would be other than small under that NAICS code, as long as each is small for that NAICS code, then it's an exception to the disqualifying certification. So it allows you to basically continue to not only to perform and get options, but also bid on new task orders under those multiple award set aside contracts. So it's a unique provision where normally you would combine those companies, obviously for affiliation purposes, and this way allows them to stay small for purposes of that multiple award set aside MAC.
So let me ask you a question about the implications of what it is you just said. Let's assume that you've got a buyer and a seller, and the buyer is still small. They're under a $34.5 million NAICS code. Their 5-year revenue average is 34 million, so they're just under it. You can see that they're going to size out soon. If they do an acquisition before they size out of a set-aside company, then they get to keep all the backlog. If they wait a year and now they've just sized out, so they're not small, they cannot do that same acquisition and get the backlog. Is that accurate, Todd?
Yeah, I think you are accurately describing a situation for, a company that is on the cusp of, of a graduating small business, right? So, you're doing the 5-year look back, and you see that you're about ready to bust through, your primary NAICS code. That now would be the time to do a deal, right? Because you would be able to, keep that set aside MAC that you've acquired and that backlog. Because it's basically an exemption from what would otherwise be a disqualifying recertification.
Got it. Marlena, do you have any thoughts about what's on this? Anything that you'd like to add about the impacts, exclusions from this?
I don't think so. I think, this is going to be from an M&A perspective. Small businesses might be looking to do more deals with other small businesses to take advantage of this exclusion. I think, the investments from other than large businesses after, the 1-year delay is going to probably decrease, and buyers might be looking around, at least those with restricted multiple award contracts, to see, what other small businesses are in a similar position where perhaps they're both about to size out and they want to take advantage of this, and can reach, a good price point for both of them.
Di, what are you advising your clients about these exclusions? Is there anything there that you'd like to add to what Todd and Marlena have said?
I think the only other thing that I get a lot of confusion on are BPAs, especially BPAs under GSA schedules, because the way people think about a BPA under a schedule, a lot of companies, is it's the same as a task order, and it's not. So when you're looking at eligibility for a BPA by itself, if it's a standalone BPA that's not on a schedule, that's one thing. Then what we're talking about with disqualifying everything would apply. If it's a BPA on a GSA schedule, though, your size goes, for every task order you bid, it goes back to the schedule. So if you had a disqualifying recertification on the schedule, just because the BPA was awarded to you, new task orders under that BPA are not really task orders under a BPA. They're task orders under the GSA schedule. You just look through the BPA like it doesn't exist for purposes of determining your size. So that's just a thing to keep in mind, that if you're thinking about it like, oh, I have a BPA, so I'm good for 5 years under that BPA, and every order under that BPA, I'm fine. Well, if it's a BPA under a schedule or a BPA under another IDIQ where you've had a disqualifying recertification, then no, you can't keep going after those task orders under the BPA. So just a distinction to pay attention to.
Very important. Let's go to the next slide. Okay, let's talk about the 180-day rule. I think, Todd, you mentioned this before, so I'm going to throw this to you. Could you talk about pending set-aside proposals?
Yeah, so we've had this 180-day rule out there, and so this is really kind of tweaking it to kind of make it comport with the recertification requirements here. So for pending proposals, you remain eligible for award of a single award set aside if the proposal was submitted at least 180 days prior to the acquisition. You're not eligible for award of pending proposals for those single award set aside contracts that were submitted within the last 180 days. So again, they're making this distinction between single award and multiple award. No matter what, you are not eligible for pending multiple award set aside max or task order proposals under those contract vehicles, no matter when it was submitted. So again, it's putting these multiple award max kind of on their their own table and basically saying you're just not eligible for them. Because if you did win them, you wouldn't be eligible for the order. So why even go through the process?
And just like under current law, if you've submitted the proposal and it's been awarded, then the 180-day rule doesn't apply.
Right.
This only applies for things that are still pending at the time of that.
Exactly.
Okay. All right. I'd like to turn, we have over almost 30 questions. So I'd like to take down the slides, and we will make the slides available to anybody who wants them. But now comes our fun Q&A period. Ed asks, will this rule impact SATOCs, which I'm assuming is single award task orders, as well? Marlena, could you answer that one? I don't know if he's talking about contracts or task orders.
Yeah, so it's gonna depend. Is it a single award? Is it a task order under a single award? So where there was not multiple awardees, right? So if it's a multiple award contract, there were multiple awardees. That's the MAC that we've been referring to, where you're no longer going to be eligible if you have a disqualifying certification for task orders. If it's a single award contract, so you were the only one that was awarded the contract, you can continue to receive orders under that. Obviously with the caveat, there's no other, the contracting officer doesn't ask for a recertification for that order. So that's, I think, the distinction there.
Okay, thank you. A question that came in just for confirmation. Assuming that the buyer has sized out organically before the disqualifying event, would there be an impact? I think, Todd, that's exactly what we were just talking about. If you've sized out before the acquisition, then you can't use the small business exemption. If you haven't sized out, then you can. Is that a fair assessment?
Yes. I mean, yeah. I mean, you are looking at the buyer at the time of the acquisition. You look at both concerns, right? Because both concerns effectively have to do a recertification. So you're looking at the size of the entities at the time of the triggering event.
Okay. So I am going to ask you the next question. Could you give some examples of scenario? For instance, let's assume that an X8A acquires an SDVOSB, assuming that the 8A is not an SDVOSB. So it's a small business, and they are acquiring another small business that's SDVOSB. What happens?
Yeah, so I think Marlena touched on some of this, is that if the contract you're talking about that you're recertifying under, because another thing to remember is you're not recertifying for the company necessarily, you're recertifying on a contract by contract basis, right? So if you have a contract that was small business and you're still small, even though you're buying it from a WOSB, you could recertify as small and keep it. If it is or if you are WSB and they're SDVOSB, whatever the example, right? Or if you have a situation where something was, you're an X8A and you're buying the serviceable vet, and it was a serviceable vet set aside, even if you're small, you can't recertify. it would be a disqualifying recertification because you don't qualify, even if you're small, you don't have all the qualifications. So that's part of the issue. The other thing to remember is that if you have another example would be you do an acquisition in 2025, you close the whole transaction, you recertify before January 16th, you're good to go. But then you have a 5-year recertification, 5-year period that's in June. You back that up 120 days. You have another recertification event, and now you're after January 16th. And you could have a disqualifying recertification right after you got in under the wire, and now you're disqualified again. So you got to pay attention to all of the different dates. And that's, again, contract by contract. So you can have many different floating dates that you're dealing with to determine value.
Very complicated. One of the questions that came in, and so I'll ask this one of you as well. Can you explain why options on already awarded task orders under a MAC, what happens there? That is, you're under a MAC, you have a task order, you are currently working on a option year 2. My understanding is that the buyer can continue to work on option year 2, but they will not be able to exercise option year 3. Is that accurate?
Or yeah, you're talking for the option you're on the task order itself. You know, I'd be interested in what other people think, because we've had a bit of a debate internally with what does the rule really say. I don't think it's that crystal clear as to what exactly occurs. The SBA might have intended that if you're not eligible for options under the IDIQ, you're not eligible for options under the task orders. But arguably, you can make if it's a single award task order, right? But it's under an IDIQ, can you continue to get options there? I think you're going to see both things happen depending on how different contracting officers interpret this. And for that kind of purpose, I'm not sure you could even get protests for that because it's not a new award, it's an option year. You could try to make a fancy argument that it's an improper sole source or something to that effect if you're ineligible, but that's a stretch. So that's been sort of my take, is you could probably keep them, but I am curious to see what other guidance or potential cases come out on that exact question.
Todd, I'm going to ask you to, respond to that. I see you nodding, but it seems like an area of great ambiguity. What do you think?
Yeah, I mean, this is a little bit of the unknown of the unintended consequences, right? The purpose of all this is so that you don't have large businesses competing against small businesses under these multiple award MACs, right? That's what the purpose is, right? I mean, again, what's the policy goal here? We're in the weeds here, right? We're talking about valuation, all sorts. There's a policy goal here that SBA was trying to accomplish, right? And it's been one they've been battling for years in regards to case law and how agencies interpret things. And so there is a policy goal that I think makes sense. That is, you shouldn't be able to compete after the fact on these multiple awards for the small businesses that haven't done a deal, right? Now they want to go win the work. Cy raises a good point. I have a multiple award MAC. I'm in year 2. I got 3 years left. It's a nice little award. I competed for it and I won, right? Does the agency want to then go re-procure this and not award option year 3 under that task order? I think there's some CEOs who say, no, I'm not gonna re-procure this. I'm gonna go ahead and award option year 3. I just won't count it as a small business award, which has been what you have to do anyways. You can't count these things as small business awards after the fact. So I agree with Cy. I think that, I mean, as we get into this more and actually see how it is in not only, I guess, interpreted by the SBA, but then implemented by COs, it'll be interesting to see what happens, because it does create a lot more work for the government if they then have to then recompete these task orders that have a couple years of performance left and pricing in them, right? Now they got to go back to marketplace and do a whole nother competition. And if it's above a certain value, they got to have protests. Like, why would they go through all that, right? So I think we may see hopefully see some further guidance from SBA on that point, because I think there is some gray there, as Cy points out.
I'm not sure I fully understood that. Marlena, I'm coming to you next, so start thinking about it. The whole point of this seems to be if there's a multiple award contract and you've got work under it and you sell to a disqualifying certification buyer, that you can't exercise option years. Well, clearly, one of the major impacts is that's terrible for the contracting officer because the work that they already did to issue that contract now has to be redone. What I just heard you and Cy arguing was that, wait a minute, that doesn't make any sense. That contracting officer doesn't want to have to go out and get it repriced for option years 3, 4, and 5. But doesn't that undermine the entire theory of what this rule is supposed to be about? Marlena, what am I misunderstanding?
Yeah, so I think this is going to be a really fun area for lawyers. I think less fun for contractors, obviously, with the gray here. But the distinction that I think lawyers want to argue on behalf of their government contractor, right, to the extent they want to continue performing, is, in option 1, it's, these are new task orders essentially, right? And so you don't want small businesses competing against large businesses, like Todd said, for those task orders. Exercising the option year under multiple award contract for that base contract, right? Again, putting aside the fact that they wouldn't be eligible for task orders under that, right? There's that same concept where you don't want, right, other large businesses competing against small businesses. If a task order has already been awarded, right, so you're already performing, there wasn't that obligation for the contracting officer to recompete it, right? You recertify, you can continue performing, you're not competing for that work again. Whereas options, right, if they exercise the option under the base, right, you would, putting aside that you're not eligible, but you would have been able to compete, right, against other businesses. For a task order that's new, right, again, you would have been competing against small businesses. If you already have the task order, you technically aren't competing. So I think that's the argument. I don't think the rule is entirely clear. I do think that, unfortunately, we are going to see this applied differently from contracting officers, perhaps depending on how busy they are or how close they're paying attention, because, as Todd went over, it's a notice to the contracting officer. It's you redo your certifications in SAM, and then, it's really the contracting officer that's going to be taking the action.
Let me ask the next question to you, if you don't mind, Marlena. Somebody asked, let's assume that the buyer acquires a seller and cannot exercise the backlog going forward. It's a disqualifying recertification. Can the buyer still use the past performance that the seller had under contracts, even though they cannot exercise those future option years?
Sure. So I'm assuming that this is like a stock purchase, right? And so
Yes.
there's no novation required. Then yeah, I mean, you can still use, right? The company still performed those contracts. Obviously, it's going to depend on what the solicitation is requesting with regards to past performance, but that's still the company's past performance that can be used going forward.
Okay. Cy, I'm going to bring this back to you because you started this debate. There's not a lot of clarity here, but not being able to exercise options is going to be very disruptive to contracting officers. Do you think the contracting officers will have flexibility in this interpretation, or do you think that they'll be locked in?
So, well, unfortunately, at the MAC level, at the IDIQ level, the multiple award IDIQ level, the rule is pretty clear. And people can protest you. So if you bid on a task order because the contracting officer doesn't want the administrative headache of off-ramping a bunch of people, you're going to have competitors that are going to protest you. SBA is going to find you ineligible, and you're going to go out. If the contracting officer still refused, they're probably going to go to GAO if they can. There could be some issue there with the FAFSA bar and the thresholds of when you can protest. That would be an interesting question, but I won't get into that right now. But so if you have scenarios, you're going to get thrown off anyway, let's just say. So the contracting officer is not going to have a lot of leeway there. Where they will is at the task orders. That's what we were talking about before. So if you're talking about options on orders that you already won while you were a small business, you competed and you won it, and now you're in option year 2 or 3 of a 5-year task order, that's where I think they're going to just let it ride. And I even talked to some OSDBUs last week, some of whom no longer have jobs as of yesterday, but they were the OSDBUs of these agencies were talking about how they actually disagreed and thought that this rule was going to be very bad for small companies and kind of what we're talking about, and contracting officers. So I think there's some internal jockeying as well to potentially try to walk back some of this, but we'll have to see how that goes.
Okay, Todd, a question for you. If two small businesses combine through a merger, they are small prior to the acquisition, they're now large on a combined basis. Will their subsequent bids be counted as small by the government? That is, will the government be able to take credit for it? It sounds like they still will be able to keep all the backlog, but will they be able to do future bids as small, or are they now other than small?
Well, for purposes of where the disqualifying recertification has that exemption for the small merger, right? As long as each were small. So for the purposes of those previous awarded max, they'll be fine. But for new contract awards and new things that go after that post date the acquisition, they would not be considered small.
Got it. Well, we're getting to the end of the hour, so I want to ask kind of a wrap-up question for everybody. One of the questions came in of what was the SBA's goal in making these changes? And I think, Todd, you talked about that a little bit. And what will be the long-term impact to the M&A space for GovCon? Todd, I'm going to start with you, but then I'm going to ask Cy and Marlena for their opinion on that question as well.
Well, I mean, it's been, we had the proposed rule out, it became final. It's now in effect. I think there's a general consensus that this will kind of speed up and make kind of more pressing certain small business deals this year. So Sharon and team, I hope you're staffing up. You're probably really busy. But I think, anytime SBA has this sort of kind of massive rewrite that impacts the industry, there's going to be time to kind of figure it out and see how it's implemented. So, I think Cy has pointed out a great point. I've been sitting here kind of reading the rule like word by word to see if I can find something that goes one way or another, and I really can't. So I think there's going to be a lot of opportunity for interpretation over the next year. But I do think it does create some different diligence challenges that not only should sellers be thinking about as they're preparing for sale and kind of thinking about these different lanes and the impact, but also when buyers are thinking about a target and making sure they really understand the particular contracts that they're buying and where the value is.
Understood. Cy, what do you think?
So in my discussions with some of the folks at SBA, they were pretty direct in saying they don't like the fact that private equity is getting into the small business GovCon space. I thought their issue was like the big guys buying them, which is what it was back in 2006 when the original recertification rule occurred, and they kind of said no, it's private equity. So that supposedly is their concern, to answer the question. And what's interesting here, though, too, is to keep your eye out if you're looking to sell, right? You know who's going to win from this are going to be your tribes, your ANCs, your NHOs, because they can make acquisitions and recertify as small. So you're going to have maybe a more targeted market in that respect, but the market will still exist and the value will still be there, but there'll be like a single buyer, if you will, or a single pool. So if you look at it in the 8A context right now, that drives down prices because they know they're the buyer of last resort or whatever you want to call it. So that sort of thing might still happen here, unless you get a bunch of NHOs starting up with private equity investment into NHOs, which I've talked to people about, and then you just smack with that. So let's just see. There are things that can happen and will happen.
Hey, Marlena, what are your thoughts?
Yeah, so I think, this is a big rule. We're talking about one piece of the rule as it relates to M&A. So, to kind of stick to that piece of it, I think SBA, I'll give them them credit that I think that they were trying to make it a little bit more unified with regards to creating one section, right, for the recertification, whereas before, you know, SDVOSB, women-owned small businesses, all of them had, you know, their own regulations. So I do think that they were trying to streamline the recertification rules. You know, I agree that they're trying to make it so smalls are competing for these small set-aside contracts. So I think that was probably the overall intent. There is obviously going to be impacts and implications that we've covered and more based on the value of these small businesses, who's going to be acquiring them. You know, maybe small businesses speed up their acquisition plans to happen this year. And maybe small businesses need to revisit if they can't, you know, do it this year. What does their acquisition plan look like, or what does their growth plan look like in the next 5 years? Because this new rule has probably changed what that looks like.
Excellent point. And I really think that people need to be rethinking the strategy. Again, for years that we've been saying to people, go get some BICs, go get some GWACs, go get some very large vehicles because there's value in them. Well, now I think the value is going to be a little bit more in the single award contracts because they're just not going to be impacted by this rule. I want to thank everybody. Jennifer, would you mind closing this down?
Yeah, I want to thank all of our speakers, Sharon, Cy, Todd, Marlena. Thank you so much. It was a great discussion. I know there were a ton of questions that we might not have gotten to. So if you have any questions, please don't hesitate to reach out to the panel. You can take a screenshot of the slide that's up right now. And all of the speakers' emails are on the slide. So feel free to reach out to them, and we'll keep that up for a little bit before we close the webinar. And we hope you all have a wonderful day.